application in the matter of Ceredigion Recycling and Furniture Team and Pope and others.
Yes. Now, Mr. Adams, we've read everything that we've been asked to read. We've got a maximum of half a day, so if you could focus on the points that really matter, that would be helpful, I think.
My lord, I'll certainly endeavour to. I suggested to my learned friend that I take both the permission and the set-aside application together, and I will hopefully get through my opening submissions in an hour, which will allow my learned friend now to respond, and then I'll have some time to reply at the end.
Yep.
This is my application for a review of the decision of Lord Justice Popplewell to refuse permission to appeal on the basis that the appellant is entitled to exercise its right of appeal, and permission was, with the greatest respect, wrongly refused. And for the appellant to proceed with the appeal. And it's an application for the decision to be set aside and or for the appeal to be reopened insofar as I need to, and consequently for permission to appeal and for the stay to be continued. I make the application pursuant to the court's inherent jurisdiction as recognised in CPR 3.17 and or CPR 3.17 if that's any different, and or CPR 5230. In paragraph 24 of my supplemental skeleton on jurisdiction, I stated that any review of permission is now regulated by 5230. In preparing the case, I'm not sure that that is the case.
I think that's the approach that's been taken by this court time and time again.
My lord, yes.
5230 or nothing, and despite what you say, you will not persuade this court to somehow depart from all those previous decisions. So I think you need to focus on 5230. I mean, the rest of what you say in your skeletons, very interesting, but it seems to me at least to ignore the doctrine of precedent.
Well, my lord, as the Supreme Court have just made clear in Gourlay, your lordships are not bound by previous decisions of this court in matters of practice. And indeed, this court is not competent to fetter its own jurisdiction. And if those cases were wrongly decided, your lordships, A, they're not a matter of precedent, and B, your lordships shouldn't follow them. And I do rely on 3.17.
You better show us what the Supreme Court say that could conceivably lead to us being allowed to conclude that all the cases on 5230 are wrongly decided.
Well, my lord,
don't go down that route.
Well, it was originally Chaplain and Boys, but that's been the decision of Lord Justice Donaldson in Chaplain and Boys has been reaffirmed by the Supreme Court in Gourlay, which is in the bundle on jurisdiction, which is, and
right. Tab 20.
Your lordship got there before me. And it's the passage is this was a costs appeal, but it draws a distinction between matters of practice and my lord, all the decisions on 5230 have been described as notes on practice, and this is practice if there is room for any. And in my submission, there is no room for any practice in the decision to grant or refuse to appeal, because it is either there is a case fit for appeal or there isn't. But insofar as there is room for any practice, it is plainly practice in relation to procedure. And what the Supreme Court say in Gourlay is that in matters of practice and procedure, it's primarily for the Court of Appeal. It's the Court of Appeal's primary responsibility for monitoring, controlling developments in its practice. And therefore, the doctrine of precedent, as set out in Young and Bristol Aeroplane Company,
Show us the paragraph.
37. It's a mark I've marked it.
37. Thank you. Let's just read that to ourselves.
And my Lord, Lord Justice Donaldson said the same thing a long time ago in Chaplin and Horace. My Lord, I do say it's 3.17 as well, because and in paragraph 24 of my supplemental skeleton on jurisdiction, I stated that any review of permission is now regulated by 5230. On reflection, my submission is that that is not necessarily the case, as any jurisdiction that existed before the inclusion of 5217 in the rules remains available to this court. 5230 was an additional jurisdiction and didn't take away any existing jurisdiction. And insofar as that sentence was a concession, I withdraw it. In that regard, I wish to hand out one further authority which should be on your desks, which is a case referred to by Lord Justice Robert Walker in Rinaker, in re Macro, which was a pre-CPR case in which the court held that if there was no if there was no right of appeal, the court effectively had an inherent judicial review jurisdiction in regards to the exercise of delegated powers. And I suggest, my Lord, you put that at tab 35 in the jurisdiction. The other page I've handed up is a page that for some reason wasn't scanned in the Lexis online version of Reach in the House of Lords, which is tab 5 in the permission bundle.
Okay.
My Lord, you have my skeleton argument supported the original application, which is my written submissions supporting the application for review of the decision to refuse permission, and my further supplemental skeleton on jurisdiction. All of which, subject to what I've already said, I rely on, and I invite your lordships to read as part of my submissions. As we say, there's only one issue before the court, and that is whether or not this is a fit case for an appeal. Ultimately, for reasons I'll explain, with the burden effectively being on the respondent to persuade your lordships, it is not. I propose to address the application to review the decision and permission at the same time, as I've already mentioned. And if permission is granted, I also ask for the stay to be continued. I therefore propose to address the question of whether the appellant has a right of appeal, which is properly exercisable, first, and then go on, insofar as we assist the court to do so, to address the jurisdiction points. And which is the power
approach if you're wrong about jurisdiction, but take whatever course you see fit.
Well,
I would have thought that logically, the first question is whether we have jurisdiction to reopen the application for the refusal of permission.
Well, my lord, on any basis, your lordship.
And that would involve your demonstrating either that you fall within the ambit of 5230, or if you're right about other rules, that you can point to some other rule that would help you. Because if you're wrong about all of that, then it doesn't matter one way or the other whether an appeal would succeed.
Well, my lord, it does, because if
say to the extent that part of the 5230 jurisdiction inevitably involves considering whether there's any merit in the proposed appeal. Because if you're trying to demonstrate that you've suffered an injustice, you're less likely to have suffered an injustice if the appeal is unmeritorious.
My Lord, yes, but and as your Lordship has seen, my primary submission is that I have a right of access to this court. I obtained that right of access when I issued my proceedings in the High Court, and therefore engage both the jurisdiction of the High Court, which has the original jurisdiction, and in the jurisdiction of this court, to which the appellate jurisdiction was transferred under the Judicature Acts. And if there is a proper appeal from the High Court, then I have a right of appeal, now recognised in the Senior Courts Act, and Section 54 of the Administration of Access to Justice Act 1999, on its face, is only a procedural bar that prevents me from exercising my pre-existing right of appeal by the exercise of the judge's, and I don't say it's discretion, and that is not the test, and I'll take your Lordship to the authorities on that, the exercise of the power to stop hopeless appeals. And it either is a case, and I think this is a point made by the Lord Chancellor in Lane and Esdale. It either is a case that's fit for appeal, in which case I have a right of appeal, and it's a denial of my access to this court to not let me proceed with it, or there's no realistic prospect of it succeeding, and effectively it would be an abusive process for me to pursue my appeal.
If someone has to decide whether you do have a right of appeal, here someone has decided. Supposing that we were to decide, would you still have your right of appeal? Suppose we decided you didn't, your appeal was hopeless. Would you still have a right of appeal?
Well, my Lord, you would have to decide as a matter of law that the points in this case are so well settled that there isn't a properly arguable point in the Court of Appeal. And that would open the door to me to leapfrog to the Supreme Court. Otherwise, I say, if there are arguable points of law, it's the duty of this court to deal with them first. And my Lord, we're at the permission stage at the moment. There is not going to be full argument on the points before this court this morning. And it wouldn't be right for your Lordships to seek to decide, like sometimes is done on a summary judgment application, a point one way or the other.
Can you leapfrog to the Supreme Court from a refusal of permission? Suppose the full court turns down an application for permission. Can you really leapfrog to the Supreme Court? Is that not the end of it?
If your Lordships make a determination on jurisdiction, then yes, I can. That's Kemper.
Let's just suppose you're right. So we forget about Lord Justice Popplewell's decision. And we then decide afresh whether or not you should have permission to appeal. And we refuse you, suppose.
Yes.
You can't go to the Supreme Court from that, can you?
No. Not if your Lordships refuse it on a properly exercised basis.
So some arm of the Court of Appeal is entitled to refuse you permission. And that's that.
Yes.
And the question is whether Lord Justice Popplewell was that arm.
No, my Lord, in my submission, undoubtedly Lord Justice Popplewell looked at it first. He was delegated a power by the Court of Appeal to consider whether or not permission should be refused. If he did not properly exercise that power, then this court has an inherent jurisdiction which is in the nature of equivalent to a judicial review to review the exercise of that decision. And in my submission, as the Lord Chancellor says in Lane and Esdale, the only way it can do that is by considering for itself whether or not it agrees with Lord Justice Popplewell. And my Lord, that is exactly analogous to a renewal of a permission for judicial review by way of appeal to the Court of Appeal. And Kemper effectively says as much. I'll come on to that. And my lord, in my I will therefore very briefly take the point first, because any exercise of jurisdiction is against that point. The background facts are that the appellant, Mr. Pope, and the second respondent, Ms. Cann, were the only members and directors of a company limited by guarantee, which factually had, at the time, a substantial surplus. It had such a surplus, at least in part, because the company had previously been in receipt of considerable grants of public funds. The grant monies were subject to clawback in certain conditions, and the Welsh European Funding Office took a charge on the company's property to secure such contingent liabilities. In the event, the Funding Office were content, and their lawyers were content, with that the objectives of the grant funding had been met, and therefore they released their charge. Under the Articles of Association, the members could agree to distribute the surplus to members, subject on the face of the Articles of Association to Article 5 of the Memorandum of Association, and they could, by unanimous agreement, change Article 5. And your Lordships recall Article 5 merely said that sums should be paid in return for services rendered to the company. The appellant and Mr. Pope and Ms. Capp were keen to retire and hand the business on to others, and so took advice about how they might fund pensions for themselves, and on advice made arrangements for pensions to be funded by the sale and leaseback of the company's property. Under the arrangements, the company made contributions to their SIPPs. They paid sums to their pension trustees. The trustees of their funds then made arrangements with an associated company, strictly paying a premium, I think, under an insurance policy, to effectively use the funds to enable the associated company to purchase the property and lease it back to the company. And most of those funds were provided by contributions to the pension funds. The final balance was met out of accumulated rents received. The case appears unattractive because the surplus principally represented the proceeds of public funds. There was, however, no question of the company being insolvent, and it was Mr. Pope and Ms. Cann's objective to hand on the business as a going concern, which is what they did, making a Mr. and Mrs. Thomas members and appointing them as directors, then resigning themselves. The pension provision is equivalent to some £300,000 each, being half the actual value of the property transferred, and in my submission is relatively modest by modern standards. In some respects, the judge was critical of Mr. Pope and Ms. Cann's conduct, but those conclusions depended on his legal findings that their interests were different to those of the companies and that they owed duties to future shareholders, which we say is wrong as a matter of law.
Do you really say that they were entitled to act exclusively in their own interests? When they weren't shareholders, they had no legitimate financial interest in this at all.
A private company is comprised of its members, and as a private company, those members, as was recently affirmed in Letty Mackey, are entitled, and I think Lady Arden in Letty Mackey especially referred to a members-only company as being exactly the same as a company with shareholders. The members only have to look to their own interests. The objects of the company last so long as the members who comprise the company wish them to continue. They do not settle if they put capital into the company, they don't settle it for indefinitely. And if they're only members and they're putting in, if it's a company by guarantee and they're only putting their work and effort, they put their work and effort in for the objects for the time being, and it is free for them to change those objects at any time. And very often these companies, this type of company often has many members, and they're set up in a way that it'll be almost impossible for the company to be for the objects to be changed, and they do, in reality, run indefinitely. But this company only had a very small number of members. The grant funding bodies knew that when they made the grants. And just as with grants to private individuals, it's in the nature of a grant that ultimately somebody's going to obtain the benefit of that. And
The company, for its not-for-profit purposes.
well, the company is the collective body of the members, which for the time being was carrying on a not-for-profit business. But what not-for-profit means is that no member is entitled to a division of the profits. If you look at the articles in this case, which were accepted as being not-for-profit articles, then they expressly provide the surplus can be distributed, but in return for services, not by way of right. And indeed, the Companies Act now provides that nobody other than members can have a right to the profits of a company by guarantee.
I mean, obviously, they were entitled to distribute all sorts of things in return for services by way of remuneration, but the judge said that didn't apply here, and I don't understand that to be appealed.
My lord, the point is wider than that. The point is that it is on the Salomon line of authorities that since the 2006 Act, the capacity of the company is no longer limited by its objects. And the distinction the Companies Act makes is between charitable companies, which are still subject to the statutory limitations on changing their objects and the rules on ultra vires, and as has been recently held in Letimaki, the members owe fiduciary duties to that public purpose. A private company, on the other hand, it can do what it likes within the law. And
well, within the law. I mean, it's accepted, is it, that these defendants undoubtedly acted in breach of fiduciary duty unless you do away with Clause 5 of the memorandum?
no, my lord, because what Salomon says expressly in terms is if all the members unanimously agree, there can be no question of any duty arising. I think the way it was put in multinational was there's no duty to future members, there's no duty other than to themselves, so there is no question of duty. Either the company has acted or it has not. And that's the question.
I mean, I quite follow that normally in a private company, if all the members agree, you can ratify what would otherwise be, ratify or authorise what would otherwise be a breach of fiduciary duty. But here, the obstacle is Clause 5 of the memorandum, which says you can't do these things as things stand. And then Section 63 says that if you try to change it, you commit an offence.
No, it doesn't. Section 63 does not say if you try to change it, you commit an offence. What Section 63 says is if you do change it, you may have committed an offence. Now, obviously, if Section 63, by mistake, reintroduced the ultra vires problems that preceded the 2006 Act, then one might have all sorts of difficulties.
It's not really a varies or capacity question. You were acting in breach of fiduciary duty unless you can bless it, and you can't, so long as Clause 5 of the memorandum is there.
My lord, that's one end of the telescope. That's the end of the telescope the judge looked down. And in my submission, that's wrong, because you never get to ask the question whether or not, because you have to ask who's asking the question. The company is looking back historically, and on the face of it, the company did something. If what the company did was lawful and it was authorised by all the shareholders, then the company did it, full stop.
It doesn't matter whether the company did it. It matters whether you committed breach of duty in doing it.
Well, my lord, the way that it was put in multinational, and it is helpful, which is tab 15. Yeah, and I think I've cited the passage in my skeleton argument. It is. It's the passage at do it now, my lord. My lord is getting there quicker than I am. There are each of their lordesses say essentially the same thing. The heart of the matter is therefore that certain commercial decisions were not ultra vires of the plaintiff were made honestly not merely by the directors, but by all the shareholders of the plaintiff at a time when the plaintiff was solvent. I do not see how any complaint of that can be made. There can be any complaint of that. An individual trader who is solvent is free to make stupid but honest commercial decisions in the conduct of their own business. He owes no duty of care to future creditors. The same applies to a partnership as or individuals. And then Dillon at 290, citing Salomon and the well-known passage in Salomon, the company is bound by a matter intra vires, and that use and the extent of the capacity of the company used to be an important question, because pre-2006 Act, and I think this may be where the judge went wrong, he was looking at passages that referred to intra vires by relation to the objects of a company. By the unanimous agreement of its members, is in my judgment apt to cover the present case. If a company is bound by what was done when it is a going concern, the liquidator is in no better position. It is exactly the same for subsequent members or shareholders. He cannot sue the members because they owed no duty to the company as a separate entity. That's because the members comprise the company. And he cannot sue the directors because the decisions which he seeks to impugn were made by and with the full assent of the members. That's why perhaps it is a Salomon point. But what is said in Salomon is the question never arises if what the company has done is within its capacity. And capacity is the right term. The judge tried to draw what is now historic distinction between ultra vires in a narrow sense and ultra vires in a wide sense. That there is no, as far as the company is concerned, there is no such distinction to be drawn. A company has a certain capacity. That, and in our submission, that is the capacity of a natural person subject to any specific statutory limitations. When, under its constitution, the members of the company can delegate powers to organs of the company. And when those organs act, of course, their powers, their express authority, is limited by the company's constitution. And any member has standing to bring proceedings, either in their own right or by way of representative proceedings on behalf of the body of members, to restrain an organ of the company from acting outside the constitution. But the members as a collective body are not themselves bound by the constitution. They can authorize or ratify anything within their actual capacity, which before the Riche case in the House of Lords was thought to have been settled as being equivalent to a natural person's capacity. Riche introduced the wider concept of ultra vires, which has been abolished, finally, by the 2006 Act. And my lord, that's apparent on it's quite clear on the face of the 2006 Act. I won't take your lordship to the provisions now, but in summary, by, I think, section 28 of the Act, anything that was within the Memorandum of Association is after 2006, or after the date it came into force, treated as part of the Articles, which in the memorable phrase used in the House of Lords in the Riche case, the members are the absolute masters of. They can waive anything in the Articles, or they can authorise anything outside the Articles within their capacity. And that is confirmed by section 39, which on its face is absolutely unequivocal in its terms. The validity, and we're concerned with the validity.
We're not really, are we?
Yes, we are.
We're not concerned with whether the transaction was effective to pass the money over. We're concerned with whether there's a claim against you for breach for causing it to be paid over.
No, but if it was a valid act, as Multinational says and as Salomon says, there's no question of duty.
Well, that's a different point, but we aren't concerned with validity. We're concerned with breach of duty.
No, my lord, we're concerned with validity, because if they were valid acts, then no question of breach of duty can arise. A company can't do something validly, authorise its directors to do something, and then turn round and say you were in breach of duty.
I think that may be mixing up different things. A company can do all sorts of things that are effective as against third parties. That is validity. The question is whether the person who caused them to do those things acted in breach of duty.
Well, my lord, not in my submission when it comes to what the multinational point is, as they say, they are the reason you cannot complain is they are the acts of the company. That was the passage I just
Which
read.
is why normally all the members can authorise or ratify something that would otherwise be a breach of duty, but we're still concerned with breach of duty, not validity.
No, my lord, yours says normally they can authorise. Normally is not there's no normally about it. Members can authorise anything within their capacity. And my lord, there are provisions within the, and those are ordinary agency principles.
But that's the core of it, isn't it? The question is whether these members were entitled to authorise, which is a question of whether or not they're entitled to authorise something that would otherwise be a breach, which is why the judge referred to duomatic and pointed to restrictions on duomatic.
Well, my lord, duomatic is only a formulation of how to identify the capacity of the company, because, and I think that's made clear in bill terms.
You accept, don't you, that there are limits on duomatic such that you can't do something illegal or you can't act in fraud of the company?
Precisely, my lord.
So even though those things might be thought to be within the capacity of the company, they can't be legitimately done. You commit a breach because you are up against the limits of duomatic.
Well, no, my lord, in my submission, those are not within the capacity of the company, at least arguably, because a company cannot be carried on for an illegal purpose. And if...
It's not just a legal purpose. There are certain things that the Companies Act require you...
Yes, and my lord, the classic thing is you can only make distributions out of available profits, and that's why. And equally, you can, and that is a legal limitation that applies to companies, and effectively the reason is to protect creditors, but equally at common law, if what you're doing is a fraud on creditors, then that is outside the capacity of the collective capacity of the members, because as soon as you cross the boundary towards insolvency, the interests of the creditors intervene. And
you don't have to have got to insolvency. If it's a fraud on the company, you're outside duomatic, regardless of Section 39 and regardless of solvency.
But as Salomon says, and it is the passage in Salomon, and I'll take your, the allegation in Salomon was, of course, that the wrong price had been paid for the property and it was all a fraud. And the Court of Appeal said, well, we can look at that. The House of Lords said, no, you can't. And the reason you can't, it's tab 8 in the authorities Bible, the reason you can't is if it's done with full knowledge of all the corporators who comprise the company, no question of fraud arises because you can't defraud yourself. The cases on fraud are where directors have obtained the consent of the members by fraud. And I put cases in the bundle that are examples of that. That is a fraud on the company. The directors make fraudulent misrepresentations to the members, get their authorization or seeming authorization, but in fact pinch the company's money. That is a fraud on the company, which cannot be ratified by, or perhaps more properly, was not ratified by the members because their authorization was obtained by fraud. Equally, a fraud on creditors, arises at a point where the members owe a fiduciary duty to the creditors, and it would be regarded as a fraud for them to prefer their own interests to those of the creditors. But if it is within...
For a complete answer that even in the case of fraud, if the directors are the only shareholders or members of the company, that you couldn't argue that there was a fraud, or the company couldn't argue that it had been defrauded. How do you explain what Lord Newberger said in Bilter?
Well, my lord, quite simply, and my learned friend has put the passage in her submissions.
The whole point is that where there's fraud, or as the judge found here, bad faith, he stopped short of saying there was actual dishonesty, but he certainly found there had been bad faith.
Well, my lord, I'll just pause to go to what was said in Bilter and then go back to Salomon. But the passage in Bilter, which my learned friend says is conclusive authority, is presaged
Tab 22,
I'm grateful.
page 10, paragraph 7.
My lord, from memory, the opening words of that passage as where it is effectively where there has been wrongdoing done to the company.
Yeah, where a company has been a victim of wrongdoing by its directors,
Exactly.
then the wrongdoing or knowledge of the directors cannot be attributed to the company as a defence of the claim brought against the directors by the company's liquidator in the name of the company and or on behalf of its creditors for the loss suffered by the company as a result of the wrongdoing, even where the directors were the only directors and shareholders of the company, even though the wrongdoing or knowledge of the directors may be attributed to the company in many other types of proceeding.
Exactly, my lord. But one's talking about wrongdoing on the company, and that's why it brings me back to Salomon. And one can see it in Lord Davies' judgment at page 57. And it's the last few lines of the middle paragraph. I think it is an inevitable inference from the circumstance of the case that every member of the company is assented to the purchase, and the company is bound in a matter intra vares by the unanimous agreement of its members. In fact, it is impossible to say who was defrauded. That is because the company comprises the members. The only question is whether it is intra vares. At the time of Salomon and Salomon, that was a live question because of Riche in the House of Lords. It is still a live question, but what one is looking at nowadays are statutory limits, such as non-distribution of surplus, or non-availability of divisible profits, or dishonesty against a third party, or the sort, in other words, a fraud on creditors, or the sort of fraud on the company, which is where the, which I was describing to my Lord Justice Newey just now, which is where the directors have defrauded the members and obtained their authorization by fraud. But if the members do something, which they lawfully can do, because it is within their capacity, as Multinational Gas says, relying on Salomon, relying on Horsley and Waite, which was a pensions case, in which there were no meetings or anything, that that the question is what goes to the validity of the act of the company, and that is reflected in section 281 of the Companies Act, and that's referred to in Bilter. I think it's referred to as section 2816, which doesn't exist, but in fact it's 2814. And what 2814 of the Companies Act says, nothing in this part affects any enactment or rule of law as to things done otherwise than by a resolution. The question is whether the company has validly acted by entering into the transactions in question. And that is the first question, because if the Companies Acts are valid, no question of fraud can arise, or dishonesty or breach of duty can arise for the reasons given in multinational between the company and its members who comprise the company. And, my Lord, going back to section 39, that fits entirely with the Riche case, which I will take your lordships to in a second, because the case that arises in this case is the point that caused so much trouble in Riche. And as I was just reading section 39, which is concerned with the validity of an act by a company, shall not be called into question on the ground of lack of capacity by reason of anything in the company's constitution. That fits with everything in the company's constitution now being in the articles, not in ring-fenced objects, and the members being the masters of everything within the articles. There's a provision in the Companies Act that the entrenchment provisions in articles do not affect, and do not bind the company acting with the agreement of all members. That's 22(3)(a). And in my submission, the scheme of the 2006 Act is coherent. It returns companies to their common law position, which is consistent with a company is a private association of individuals. There's no obvious reason why what they should be able to do with their company.
I have to say, if you're right, then the law is very seriously defective, because all not-for-profit companies can have their assets taken by the members, even though the members are really there only in a sort of representative capacity and aren't supposed to have a financial interest.
Well, my lord, these articles, which were available to anybody dealing with the company.
And would have
Measures-
shown that money wasn't supposed to go to the members.
No, they say by unanimous agreement, those provisions can be taken out of the articles.
Well, so we look at the.
Yeah, let's have a look at them. shall we?
So anybody dealing with a company knows at any moment the articles could be changed.
Well, if they were really on the ball, they know it was a breach of section 63.
Well, no, because you can change at the same meeting. You can change the name of the company. You can do it all in the same meeting.
There may be a lacuna in the law in the sense that you can take out, you can add back in the limited and pinch the money.
Well,
But as things stand, clause 5 bars members taking the money.
Well, my lord, if one looks at the relevant clauses, and there are a couple of mistakes in them, my lord, there are two answers to that. First, it depends on the membership. If it's a not-for-profit with a large membership, then which many are, and many are set up to have a large membership, the prospect of there being unanimity is greatly reduced, and for all general purposes, the company is going to continue for the foreseeable future, and not having limited its name is a convenient vehicle for that sort of organisation to operate under. And effectively what section 63 said, section 62 and 63 take together, that if you're going to decide, and there's nothing to stop the members deciding at any point, they haven't dedicated their assets for charity. That is the difference between a charitable company and a private company. They can, at any time, they can change the articles to make it not for profit. What they must do at the same time is change the company's name. Otherwise, they commit an offence. But if they continue to trade, but what is meant, and I can take your lordship.
If they don't change the name of the company, which they didn't do here, then what they're doing is illegal. It's a criminal offence.
Well, my lord, no, because there are steps to that argument. That if one looks at the articles, these articles, it says 3.3 on page 159, tab 10. It's in fact 3.4, and I'm afraid it's repeated over the page. But 3.4 was to, if your lordships want to see my learned friend suggesting your lordships may wish to look at the entire. But I'm
It's a
sure
supplementary bundle, tab 1, isn't it?
My lord, yes.
And that we're principally concerned with 5 on page 4.
Well, my lord, if one starts at 3.4, one of the objects of the company, so pre-2006, one of the objects of the company, and it's now part of the articles, to engage in any business or trade or industry which may seem to the company directly or indirectly conducive to the interests or convenience of the company's members or any section thereof. So it is authorised to carry on business for the benefit of its members. Then, if one looks at, it has various powers in furtherance of the objects, and that reflects the language of the ultra vires doctrine prior to 2006, that you could have various ancillary powers to the objects that limited the capacity of the company. And that you can sell the property, you can mortgage it, you can do all the things that were done in this case. Not that I say it has to be in the articles to do it. Then 5, the income and property of the company, whensoever derived, shall be applied solely towards the promotion of the objects of the company, as set out herein, which includes benefiting the members. And no portion shall be paid or transferred directly or indirectly to the members of the company, except by way of payment in good faith of reasonable and proper wages, bonuses, and I'll come back to the word bonuses, and repayments, including loans, of expenses to any member or employee of the company. And the important words I rely on are in return for any services actually rendered to the company. Because the real complaint in this case was that the remuneration was excessive, not that it was entirely unlawful. My learned friend is suggesting that, because technically the hoops in the articles were not jumped through, then the current member is entitled to the entire surplus. Because after 9, and then after 9, there's an important, 9 is the bit about, in the event of dissolution and winding up, after satisfaction of debt and liabilities, it either goes to a company of similar objects or charity. But after that, it expressly says, this clause 9 and clause 5 thereof may only be changed by unanimous vote of all members at an extraordinary general meeting. And section 17 of the Act shall not apply. But that makes it quite clear that at any time, the objects could be changed by the unanimous agreement of the members. And if one looks forward in the articles to 58, the surplus funds of the company shall be applied in the following ways, in such proportions and in such manner as may be recommended by the Management Committee and approved at general meeting, creating a general reserve as a distribution to members of the company through a suitable bonus scheme. So on the face of the articles, the members were entitled to be remunerated out of the surplus and could be remunerated by way of bonus. And the difference between a bonus and a dividend is a bonus is gratuitous. It is decided on from time to time by the proper organ of the company in its absolute discretion. Whereas a dividend is an entitlement to a division of the surplus. And that's the difference in a not-for-profit and
Now, Mr. Adams, you've now been arguing for 55 minutes about the appeal for which you did not get permission to argue. We are concerned with whether there's a basis for reopening this appeal.
my lord, yes,
I suggest you use up the time you've got left to address us on that if you want to.
my lord, I certainly do wish to. My lord, my lord, I hope to be through in an hour, and that was, of course, subject to your lordship's.
Except you've been, as my lord politely says, you've been diverted. We have asked questions, so. But we've got your point about
my lord,
the
yes.
merits of your case, but you've been refused permission to appeal.
Well, my lord, in my submission, there is a properly arguable point. Indeed, it's an important point. These are important points that arise out of a relatively recent change to companies legislation. They're the same point. I was going to take your lordships to Riche, but that went 2-1 at first instance in the Court of Exchequer. It went 3-3 on appeal to a division of the Court of Exchequer, 3-3. And in my Scotland argument, I said Mr. Justice Blackburn was at first instance in Riche. He wasn't. He was in the Court of Appeal, and then it went to the House of Lords. But it was thought settled at first instance that the capacity of a company was the same as a natural person. That was upheld effectively in the Court of Appeal, and it was not decided in the House of Lords. We are back to the same point now. It is an important point. It is a difficult point, and that's why I have a right of appeal to this court. If the point is properly arguable, my starting point is a right of appeal, and any exercise of power to refuse permission is, unless my appeal is hopeless, and interference with my right of access to this court. And my Lord, if I can deal very shortly with the test of permission, Lord Wolfe addressed the question before the CPR came into force. And he did so in a case called
Well, we know what the test for permission is because we apply it all the time, whether there's a real prospect of success opposed to a fanciful one.
Well, my Lord, this is important because it was expressly endorsed by the Bowman Committee and then enacted in the CPR. It's sorry, I've lost it again. It is Smith and Cosworth, which is
Tab 12.
tab 12. Paragraph 1, the court will only refuse, emphasise refuse, because this is a power to refuse, not to grant. And the reason it is a power to refuse, not to grant, is that the starting point is you have a right of appeal. It is different to a statutory appeal or a second appeal, where very often the right of appeal only arises if it is granted, if permission is granted. Lane and Esdale establishes that there is no right of appeal from that type of grant of permission. It was explained in Rickards that was the only meaning of Lane and Esdale. This is a completely different sort of power. The starting point is not that you don't have a right of appeal, which must be granted. The starting point is you do have a right of appeal. And the question is whether to refuse it.
But 52.3 of the CPR says an appellant or respondent requires permission to appeal, and then explains what the test is for permission to appeal. 52.5 deals with determinations for permission to appeal to the Court of Appeal. So you don't have a right of appeal under the law as it now stands. You require permission to appeal. In the same way as you would if you were seeking to appeal from this court to the Supreme Court.
My
I
Lord,
don't understand your argument in your skeleton to the contrary.
well, my Lord,
Contrary to the rules.
it's quite a simple argument. My Lord, and I'm sorry, my Lord, if I didn't get it across.
Are civil procedure rules not statutory in this country? I thought they were.
They are statutory, but they are nothing to do with the court's substantive jurisdiction. In this case, for the reasons given in Silem, the right of appeal is completely separate from the.
Although we're not bound by decisions as to practice, we're bound by the decision of the House of Lords in 1864, are we?
My Lord, because that goes to jurisdiction. What was held in that case was the court was not competent to either give itself a right of appeal and by the same token, by its own decision, take away a
The Court
right.
of Appeal has jurisdiction, indeed the duty, as you submit, to develop its practice. Why on earth wouldn't it develop its practice so that it accorded with the civil procedure rules?
My Lord, in my submission, there is no room for practice. Because of the test in Smith and Cosworth, Smith and Cosworth is adopted in terms in the Bowman report as the test. And it is only a power to refuse because there is a pre-existing right of appeal. And that I think that's accepted in the Bowman report. Because if one looks at section 54 of the Access to Justice Act, it is a procedural provision. It only empowers the court, rules of court to be made, which for the reasons in Silem are different from the court's substantive jurisdiction. Rules of court may provide that any right of appeal, so the first question is, do you have a right of appeal? Yes, under section 16 of the Senior Courts Act, which was a common law right of appeal transferred to this, which was confirmed by the Judicature Acts. any substantive, justice requires there to be an appeal from any final decision of a court at first instance. That was recognised at common law, it was put on a statutory basis by the Judicature Acts, and it remains in the Senior Courts Act. I have a right of appeal. May be exercised only with permission. So I can only proceed with my appeal procedurally with permission. It is a procedural bar. And that's why I say it's very like judicial review. You can only proceed with permission. And though the rules put the Smith and Cosworth test in a positive way rather than a negative way, that doesn't affect the nature of the power, which is to refuse permission. And my lord, the next step in the argument is that why before 5217 was there no provision in the CBR to revisit the a refusal of permission? And the answer is there was. And it was in, there was an express provision in the CPR, which was originally in 52.9, but is now in 52. I think it. Right, based on my submissions, I'll tell your lordships immediately. The provision that a grant of permission can be set aside on the application of the respondent demonstrates that from the outset, from the initial enactment of the CPR, the court could review the decision of a single Lord Justice to grant permission. And as is said in the passage in Kemper in my submissions, you either can review a grant or a refusal, or you can't do it at all. It was made clear on the face of the CPR, and I think it's now 59, sorry, 52.8.
It's 52.18.
18, yes.
52.18 is dealing with the obverse to what we're concerned with. That's the position where the respondent seeks to set aside the grant of permission. And it makes it they're very rare. And 52.18.2 says the court will only exercise its powers under paragraph 1 where there's a compelling reason for doing so. And then it goes on to say in 3, if there's been a hearing and the respondent was represented, that's an end of it if permission is granted at the hearing.
My lord, yes.
And the usual answer to these sorts of applications, which we do occasionally get, it's fair to say, is, well, you had the opportunity to put in your respondent's statement under rule, whatever, 52 practice direction point 19, and the court's taken that into consideration. Well, it says nothing about the circumstances in which where there's been refusal of permission. You can reopen, and that's dealt with by 5230.
Well, my lord, in my submission, both Kemper and Rickards effectively say what is source for the goose is source for the gander. Either there is a power in this court to review the decision of the judge considering permission, or there is not. If there is a power, it could be exercised either on the application of the respondent or of the applicant. And what 52.18 does is reflect what is said in Smith and Cosworth. Smith and Cosworth says you only refuse permission if there is not an arguable point. Even if there's not an arguable point, you don't necessarily refuse permission. So it should be incredibly rare that a respondent is able to set aside a refusal of permission. And that's why I say the burden is ultimately on the respondent to prove that the case is not fit for an appeal. And the reason, and my lord, the final piece of the jigsaw in my submission is the case I've handed up this morning, In Re Macro, which was a case, I think, of Mr. Justice Ferris, but it cites extensive passages from an earlier decision of Mr. Justice Wolfe in a case called Beeline, which effectively says where the court has delegated a power and there is no appeal, the court has an inherent jurisdiction analogous to judicial review to review that decision. And my lord, that is the court's inherent jurisdiction. It is regulated in respect of the respondent by 5218. It exists for the appellant. And if one wants a source for it in the CPR, it is 3.17, which says that where there is a power, the court, a procedural power under the rules, the court always has the power to go back and revisit that decision. Because either the power was properly exercised and there was never a right of appeal, or it was wrongly exercised and has, on the face of it, wrongly barred an appeal which is fit for purpose. And if it is a proper appeal, then necessarily the judge's decision was ultra vires, because he has no discretion to oust the court's substantive jurisdiction. Section 54 is not an ouster clause. It doesn't oust the court's substantive jurisdiction. My lord, the propositions I've taken from Silim, I've put in my supplemental skeleton at paragraph 6. An appeal is the right, I emphasise right, and that is a distinction that's made by, I think, the Lord Chancellor in Silim, of entering a superior court and invoking its aid and imposition to redress the error of the court below. That is my right. I'm entitled to the assistance of this court if it is proper for me to proceed in this court. An appeal itself is independent of any rules of practice or procedure. The creation of a new right of appeal requires legislative authority because it is not within the competency of a court to grant itself or take away its own jurisdiction. Its duty is to exercise its substantive jurisdiction, and its rules of practice and procedure are only ancillary to the exercise of its substantive jurisdiction. And that's why a new right of appeal requires legislative authority. And in fact, a right of appeal is the transfer of jurisdiction from one court to another. It's trite that the court's substantive jurisdiction originally comes from the Crown. It can be redistributed by Parliament, but it arguably cannot be taken away. And the court is not competent of its own motion to affect its jurisdiction. And effectively, that is a requirement and my lord, I've been rushing through slightly.
But it can be limited, you would accept, by rules of court.
No, not the substantive right of appeal, no.
So in other words, you could ride roughshod through 5230 if you can show that you, to a different judge or a different series of judges, the one who refused permission, that on your case you've got an arguable point of law.
Well, 5230 as enacted dealt with a different problem.
We will be inundated with applications like yours, if you're right. And if you look at the notes to 5230, which give the history of this area of the law set out extremely clearly, it was as follows. So, yes, you're right about inherent jurisdiction in the sense that there was nothing in the rules originally, and Taylor and Lawrence recognised an inherent jurisdiction to reopen in certain limited circumstances. That led, as the notes say, to hundreds of unmeritorious such applications. And accordingly, the rules have changed. Rules 5217 was originally put in the rules, what's now 5230, which limits the right to seek to reopen refusal of permission.
My lord, yes, I think it was noted. I think there were a couple of cases.
And everything in 3.1, as 3.12 makes clear, the powers that are given under 3.1 are subject to any other provision of these rules which says otherwise, which would include 5230. So there's not some freestanding right under 3.1.7.
My lord, I think
I will get into 5230. So you were quite right in your skeleton argument to say this is all regulated for appellants by 5230.
My lord, can I answer that point? It takes a little bit of unpicking, and I'm fully conscious that it was noted in Matselek and I think Bamji that in the first year after Taylor and Lawrence there were 200 applications made to reopen appeals, nearly all of which were misunderstood the jurisdiction and took up an inordinate amount of the court's time. But my lord, first of all, I say, if people are making inappropriate applications, and that is taking up court's time, then the court should be looking for a procedural solution. It cannot, of its own motion, restrict its substantive jurisdiction to avoid a procedural problem. And one could easily imagine that the court could, for instance, require a certificate from a higher court's advocate for such an application to be made. They would owe a duty to the court, which could be enforced by the court.
The procedural solution is 5230.
My lord, I'm coming on to 5230. 5230 deals with a different point, as did Taylor and Lawrence. If there is a proper exercise of the power to refuse permission to appeal, i.e. a lawful exercise of the power to refuse permission to appeal, and this was Udin, I think, not Taylor and Lawrence. Taylor and Lawrence was a fully argued appeal. It had been finally determined on the substantive merits, and therefore the matters were on the face of it raised judicata between the parties. So and that's where the court first started with a reserved jurisdiction, because if the court has exercised a substantive jurisdiction, then according to that determination, it should only interfere with that if justice requires. It was the same in Udin. There was no complaint that permission had been wrongly refused in the first place. If there is no complaint permission was wrongly refused in the first place, then Section 54 is an effective bar in the nature of a statutory limitation on your right to proceed with your appeal. And so you're again in the same territory as the Amptil peerage case and the like. It's a reserved jurisdiction which could only be exercised in exceptional circumstances to set aside. But if one's looking at the question of whether or not the single Lord Justice has properly exercised the power to refuse permission, then one's asking the question as to whether the appeal has been brought to an end or not. And in a sense, there's no need to reopen the appeal because the decision will have been a nullity on Ali's minute grounds. The right of appeal still exists. And all the court is doing is, in order to do justice, and this is why I refer to the decision, the procedural decision in Dimmock's and Todd. It's a different circumstance, but if the court is seeking to do justice, exceptional circumstances merely takes outside the ordinary rule. If the court is faced with a prima facie legal position or a res judicata, then the court is only exercising a reserve jurisdiction. And that will require exceptional circumstances where justice demands. But if one's still at the stage where one is considering whether or not to set aside the first order, then on the basis of macro, the court has an inherent jurisdiction. That was referred to by Lord Justice Robert Walker in Rickards. And
Can I just interrupt one moment and be clear?
Sorry.
So any refusal of permission which was in fact erroneous is void.
well, my lord, there's a presumption of legality, just with like any.
Quite, but fundamentally, any refusal of permission which is wrong is void.
My lord,
And that's
yes.
presumably whether it's taken by a single Lord Justice or this court, the full court.
My lord, yes, and my lord, I rely on the Lord Chancellor in Silem for that proposition. Or no, I'm not in Lane and Esdale. Because what was said in Lane and Esdale, and it is right, and it is why an appeal from a refusal of permission, of permission for a judicial review is by way of rehearing, is the only way that a reviewing court can consider whether or not the power was properly exercised, is by asking itself whether or not it agrees.
So just to be clear, suppose this full court says that your appeal shouldn't have permission because it hasn't got enough merit, but leave aside the 5230 considerations. We say there is not a real prospect of success. Well, that decision would be void. And you could presumably apply to another full court to see if they agree.
Well, my lord, one might be, I suppose one might be in, my lord, any review is a discretionary, is in the discretion of the court. It's like a judicial review. I have no right to the review.
I thought the first decision was void.
Well, I suppose if you're in the territory, then I mean discretion in the sense of judicial review is discretionary. If a public authority has acted outside its powers, then one has to seek permission. In a sense, it's not discretionary because if there is an arguable point, permission ought to be given. But the court only, which would affect the outcome. But when one applies for the review, and whether one does it under 5230 or 3.17, which is what one would have had to have done before 5217 was enacted, the court, if the single Lord Justice looks at the decision and agrees, then they're not going to give permission for a review. Because
But that would itself be effective, I suppose. You just come back again.
It's
Should
just
find
it's a
somebody who
never-ending
agrees.
spiral on your case. You go on trying to find a Lord Justice who agrees that you've got an arguable point, at which point you say, aha, well, everything that's happened before is void.
or maybe until they'd all died and you had a new set of Lord Justices.
I'm not being facetious, Miss Adams.
No, my lord, I was making
I know
reference to the Lord
This is a
Chancellor's
very ingenious
justice.
argument, but you've got 5230 slap bang against you with respect. And you simply haven't addressed us on a test in 5230 after an hour and 20 minutes.
Well, my lord, my lord, I on the test, and my lord, my submission is that, as a matter of, for the reasons given in Lane and Esdale and Kemper, which I haven't had a chance to take your lordships to, but I urge your lordships to read, which approves the analysis of Lane and Esdale in Rickards, and makes the point that any principle applies just as much to the grant of refusal, grant of permission, as the refusal of permission, then the court, it is in the nature of a review, which is analogous to an appeal, that's what's said in macro, which has to address the substantial issue as to whether or not the power was properly exercised. But there is no appeal from such a decision. That is Lane and Esdale. So if this court properly exercises its jurisdiction, there is no appeal to the Supreme Court. And once it's been determined inter partes, on the face of it, as I think there is some authority on 3.17, one cannot apply it back unless there's been some sort of radical change of circumstances. And then one, in effect, one would be in reopening appeal territory, because the point has been finally, as far as this court is concerned, the point has been finally determined. Now, if the court makes a decision about jurisdiction and gets it wrong, then there might be an onward appeal. And if the court purported to decide an issue of law, then there might be an onward appeal. Because in my submission, it's inappropriate for a court at a permission stage to be taking its own view on issues of law that are properly arguable.
That's quite difficult. Well, I mean, it's properly arguable, but if the court has to decide whether it's properly arguable, inherent in that is that it might have to decide the law in order to decide that it isn't properly arguable.
Well, my lord, it only has to decide whether or not the law's been settled. And in my submission, that would be such that you'd have a leapfrog appeal. For the system of appeals to be coherent, if the point has been settled, then it's not appropriate for the Court of Appeal to take it. You can go straight to the Supreme Court. And that is how that. If, however, in the terms identified in Smith and Cosworth and cases subsequent to the CPR, such as Tanfer, the point is properly arguable, then it is the duty of the court to deal with it. And as tempting and pragmatic in the short term it might be to be able to exercise an autocratic power, in the long term, it would tend to bring the administration of justice into disrepute if important points were rejected at permission stage, leave individual litigants aggrieved, and their lawyers exposed to unwarranted complaints and claims. An individual judge, it would also make permission a lottery on whichever judge happened to look at it first. The judge, sitting alone in his room in private, deciding whether to refuse permission for a first appeal, does not, at the stroke of a pen and in the exercise of any discretion, decide which litigants should have access to appellate justice and which should not, or which arguable points of law are worthy of consideration or not. He has a limited power, as under summary judgment, to refuse permission where the appeal is hopeless. I can ask another Lord Justice to look at it, and if the parties are legally represented and the first Lord Justice has given some reasons, it should not be an onerous exercise for the second Lord Justice to say whether or not they agree. If they're in doubt about it, if they disagree with the first Lord Justice, then necessarily the point is arguable and the appeal should proceed. If they disagree and they're confident in their disagreement, they can grant permission there and then on paper. If they're in doubt about the matter, they can adjourn the matter into open court, and the matter can be heard as today, in exactly the same matter as a renewed application for judicial review. And if that generates an unwarranted and unnecessary amount of unmeritorious applications, then the court, together with the rulemaking bodies, must find a procedural solution to prevent that.
Unless you're completely wrong, and the court's already found a procedural solution in Rule 5230. Because although Lord Justice Popplewell didn't use the word hopeless, he certainly said that the judge was unarguably right on the 2 points which he said were fatal to your appeal. So it's pretty close to saying it's hopeless.
Well, my lord,
But you say you can go off to another Lord Justice and see if you can persuade somebody else to reach a different conclusion.
my lord, I say he was wrong to say it was
So we've
hopeless.
got all those points. What we've been exploring now is the limits on where you can go when you've had a refusal of
Well,
permission to appeal.
My lord, at first,
I understood your submission to be that the refusal is, if you can show it's wrong, then it's void, and you can simply go to another member of this court to seek to get a different decision. Have I got
my
that?
lord, I'm entitled to go to another member of the court to review the decision of the first. That is required for the administration of justice. And it is effectively required to be consistent with the rule of law. For there to be law, there must be an authoritative voice that can speak as to what the law is. The state can only speak with one voice as what the law is and what justice requires in any particular circumstances and in any particular place. And it's been settled, at least since the case of prohibitions, that that is the voice of Her Majesty's judges, whose duty it is to judicially determine such issues. That is, sitting in open court, hearing argument on the points, and giving a reasoned judgment in public.
So in other words, the provisions of the CPR, which provide for permission to appeal applications to be dealt with on paper, are contrary to the rule of law. Is that your submission?
No, because if
They're capable of being reviewed in every case.
yes,
Who decides which ones get reviewed otherwise?
who renews their application for permission for a judicial review to the Court
Anybody
of
in
Appeal?
that case. Anybody who's aggrieved simply makes an application to another member of this court on your case.
Yes, and if that second person agrees with the first Lord Justice, that's an end of it.
Where does it say that in the rules as a matter of interest? Or doesn't it?
Well, 3.17 says you can always, 3.17 is in terms.
But sorry, why would that be the end of it? Because that decision would be void. If they got it wrong.
Well, that was the position the Court of Chancery was in before the 1854 Act. And you could go back to the Lord Chancellor any number of times. In reality, you had to wait until there was a change of Lord Chancellor. But the reality is, no, this court will not, where a matter has been looked at by two Lord Justices, this court is not going to look at it again in its discretion. And there is no appeal from either decision. That is why one has to come to this court for a review. And I suppose if somebody vexatiously keeps on coming back, then there are provisions in the rules dealing with such vexatious litigants. And in simple terms, it's Her Majesty's judges sitting in a judicial capacity who exercise the judicial power of the state and no one else. The single Lord Justice does not have power to oust a proper appeal. And if one wants an authoritative statement to that effect, then one looks to Lord Justice laws in the Court of Appeal in Cart at 36 to 38 and at 80, where he tackles what the rule of law requires in circumstances such as this. In the Court of Appeal in Cart, the Court of Appeal tried to draw a distinction between errors within jurisdiction and errors without jurisdiction. That was rejected in the Supreme Court. Because since Anne's Minute, there is no distinction between errors within jurisdiction and errors without jurisdiction. Now, Cart was dealing with a different situation. It was dealing with an inferior tribunal having the power whether to grant or refuse permission. That is what is identified in Lane and Esdale and Rickards as an appeal by leave. If you don't have an appeal unless it's by leave, then there is no appeal from that decision, and the court has a discretion as a matter of practice and this is where practice does come in, as to when it should review the decision of an inferior court. And what the conclusion that House Lords came to, or the Supreme Court came to in Cart, was that the appropriate practice when was undertaking that sort of review is the second appeals criteria, which was to prevent important points slipping through the net. But it is different where the question is whether this appeal finality has been brought to this appeal or not. If a Lord Justice goes outside the ambit of his power to refuse permission, then by definition, he is ousting the court's substantive jurisdiction.
Who decides whether the Lord Justice has gone outside his or her ambit?
This court, exercising its supervisory jurisdiction, identified in macro, enacted in 317. And my lord, no doubt, you know, it's not unusual for cases to come before this court where permission has been granted on one ground and refused on another. It might be difficult to do justice to the case without considering both points together. In those circumstances, the full court hearing the matter could.
They could actually.
Yeah, well, my lord, they
permission has
could.
been refused on the ground. I'm not sure you can.
No, this is the whole point. They can, because if the,
Well, you say you.
I say they
That's
can,
commonly
because if the
understood,
single
I
Lord
don't think
Justice has
it's-
got it wrong,
Yes.
the full court, when they're looking at it, and it's not unusual for single Lord Justices to get it wrong. There are many cases where the court has said permission shouldn't have been given because this was unarguable, or the other way, the permission was given on the wrong basis, or you know, the court, to do justice to a case, must be able to review the decision of the single Lord Justice. You know, there's a the Brownlee case has just been considered for the second time in the Supreme Court on the point that permission was given for, but which clearly interrelated with the point for which permission wasn't given for, which in my submission makes it very difficult to do justice to the case. And the court exercising the substantive jurisdiction must have ultimate control over the proceedings. Otherwise, this court is deferring inappropriately to the paper exercise undertaken by the single Lord Justice. And my lord, if I do now go to 5230, and my lord, I'm not going to take you through all the cases because, my lord, in essence, the difference I have between the practice as enumerated in the existing cases, and particularly in Goring, which I think is probably
Goring on Thames.
Goring on Thames 26 is one it's often referred to.
Yeah.
Paragraph 27, it was conceded in that case that the jurisdiction under 5230 was very limited. I'm not making that concession in this case.
Right.
And it was conceded that it must be shown more than simply the decision to refuse permission was wrong.
You still have to satisfy the conditions in subsection 1, though, don't you?
Well, my lord, first of all, 5230 does not apply if the appeal has not been lawfully closed. That's my first.
Well, you've made that point. We've got that point. We're just looking at
If it does apply, then 29, and this is on the basis of it was conceded that it was tightly constrained. It is exceptional in the sense that it was engaged only where some obvious or egregious errors occurred in the underlying proceedings and that error has vitiated the very process itself. Now I say the decision is vitiated on anisminic grounds if the judge has made an error of law. If he thinks the point is settled when it is in fact not settled, he has made an error of law. That vitiates the decision. Now it says that CTU 30 jurisdiction will never be engaged in because it might plausibly, even cogently, suggest the decision in the underlying proceedings, whether to be a decision on a substantive appeal or a decision on application for permission, was wrong. The question of whether the decision in the underlying proceedings was wrong is only secondary to the prior question whether the process itself has been vitiated. Even if that prior question is answered yes, this will only be reopened if the court is satisfied there is a powerful probability that it was wrong. In my submission, powerful is the unnecessary word there, because either, for the reasons given in Lane and Esdale, either the case is fit for an appeal or it is not. Either it is wrong or it is not. And if it is wrong, it has vitiated the process.
To be clear, that paragraph is completely wrong, really.
Which paragraph are we looking at?
Paragraph 29 of Gore,
29.
because that plainly proceeds on the basis that the first decision might be wrong, but nevertheless the court won't intervene because there's nothing obvious and egregious.
Well, my lord, yes, and in my submission, the exceptional circumstances under 52, but that appears to be suggesting it's some sort of discretionary exercise whether or not to grant permission, and it is not.
I'm not sure it's discretionary. It's, for 5230 purposes, we have to look to whether there was some obvious and egregious error.
My lord, the obvious and egregious, if one has to look for an obvious and egregious error, in my submission, one finds that in thinking a point which is of huge importance and plainly arguable was so settled that it was not fit to go to the Court of Appeal.
So when the Court of Appeal say it follows that the CPR 30 jurisdiction never be engaged simply because it might cogently be suggested that the decision refusing permission was wrong. That's just wrong as well, is it? That's what, an impermissible
my
loss
lord,
on the jurisdiction?
My lord, my primary submission is that that is not an exercise of the 5230 jurisdiction. One hasn't got to 5230 if one is reviewing.
We got your point about that, but we're looking at 5230.
If I am under 5230, yes, then it is wrong.
And there
And-
you say, well, however many decisions of the Court of Appeal there might have been before on the very point, they're not binding.
No, it doesn't make it any better just because you've decided the same point, the same way. On concessions in most of these cases, the same way, that doesn't bind this court. And the reason that, in my submission, the Court of Appeal has gone wrong is to conflate the Taylor and Lawrence and Udin situations, where there's no question the appeal has either been finally determined or there has been a lawful exercise of the permission to refuse. In one case, I think they were trying to introduce new evidence. In the other, there had been a change of circumstances since the refusal of permission. In those circumstances, it is right, exceptional circumstances means until peerage type exceptional circumstances. Where, however, the question is whether the appeal has been finally closed, and which depends on an exercise, the proper exercise of the single Lord Justice's power to refuse, then the court is still concerned, because it is not according to any final determination or law, it is still concerned to do justice in the case, and its primary responsibility is to do justice in the case. And if, plausibly, the single Lord Justice has gone wrong, then this court should consider, the full court, if necessary, on argument, should consider whether there is a proper point to go on appeal. And, my lord, the Smith and Cosworth test is not intended to be an onerous process. single law justices are not meant to be wading through the papers, trying to find reasons why it might be, and take their own view on the case. All they are doing is weeding out the frivolous or vexatious appeals.
Well, that's what you say, but that is not how the test is applied. The test is whether or not there's a real prospect of success. So it's not just weeding out frivolous or vexatious cases. It's whether there's a real prospect of success. Very often you can say, well, it isn't an arguable point. There's no other substantive reason. So you refuse permission to appeal. But it doesn't mean it's frivolous or vexatious.
Well,
Some of them are, but not all.
Well,
Anyway,
my lord,
we've got your submission about Smith and Cosworth.
well, my lord, Kemper does say something on, I think, on that point. And Smith and Cosworth, it just reiterates what is said in Smith and Cosworth, that it is a limited power to prevent effectively abuse of the appeal process. And I won't take you to lordships now, but Kemper does do an interesting analysis between judicial review and appeal and the similarities in certain circumstances, and why, if there isn't if one can review a refusal, one can also review a permission. And the purpose of the exercise of the power is to stop, well, on the summary judgment test, appeals which have no prospect of success. My lord, if that causes resource difficulties, and it is my submission for the Court of Appeal, in my submission, that's not the Court of Appeal's problem. And if the Court of Appeal tries to ameliorate the situation by not doing justice in the cases before it, it covers up a problem that exists for somebody else, or one that cannot be solved solely by the Court of Appeal. That was the position at the time of the Bowman Review, when appeals were rejigged and consideration was given to permissions to appeal. And if it causes resource difficulties, then that issue may have to be revisited. But this court is not competent to refuse to entertain proper appeals simply because it doesn't have the resources to deal with them as quickly as it would like to do so. And my lord, going back to whether the point is arguable, just finally, in Riche, at first instance, it was held by Mr. Baron Channel, it's page 227, tab 4. Baron Channel held, seems clearly settled by the more recent authorities that in the case of companies such as that in the present case, the persons constituting the company, that is to say the shareholders, may bind themselves in their corporate capacity by their individual consent to contracts not authorised by the Memorandum of Association or other like instruments by which the Constitution is defined. Mr. Baron Channel thought it was settled. He was in the majority at first instance.
There aren't any shareholders here, of course.
My Lord, no, it went on appeal, and Mr. Justice Blackburn cited that passage from Mr. Baron Channel's judgment and held that though he didn't think it was as settled as Baron Channel thought it was, he thought that the law was right. He identified the question as whether Parliament, by statute, had limited the prima facie common law powers of the company.
So which wish.
My Lord, I think I'm struggling between them.
Whose judgment are you looking at?
Mr. Justice Blackburn.
That's in the Court of Exchequer Chamber, is it?
Yes, that was on appeal. Because at that stage the appeal was to the same court but a different division, effectively. And he cites the passage at just 261 over to 262. He's starting with my late brother Channel.
Yeah.
And he then refers to the authorities which he presumes he was relying upon. Mr. Justice Blackburn says, I think it's too much to say these cases clearly settle the point. Instead of saying that these cases clearly settle that law, as is my brother Channel says, I only say that I think that, my Lord, did I say brother rather than Baron? I apologise. I think them authorities to that effect, and I think such is the law. With this slight alteration, I agree entirely with what is above quoted. And the Court of Exchequer Chamber split 3-3 on whether, and then he goes on to consider whether the 1862 Act and whether it had limited the powers of the company to the objects. And he thought it had not.
And your point is simply that we've gone back to the position as expounded by Channel.
It went to the House of Lords. It was held in the House of Lords, which started the whole doctrine of ultra vires, that the 1862 Act had limited the capacity of the company to its objects. And therefore, though the members were masters of the Articles of Association, they could not go outside the objects unless and until they changed them by the statutory process. And my Lord, that has gone in the 2006 Act, and we are back to Mr. Baron Channel's view of the law.
Thank you. Yes.
My Lord, I don't intend, unless I have a contrary suggestion from you, to deal at any great length with the argument as to jurisdiction of the Court of Appeal generally, whether 5230 is the test that we are applying or otherwise. If it would be of assistance to the court, I'm very happy to respond on that.
Well, one case that Mr. Adams hasn't addressed us about is Tibbles, which is the decision of the Court of Appeal, where Lord Justice Ricks sets out what the limits are on the jurisdiction under 3.1.7. And they certainly don't include what Mr. Adams contends for.
Well, indeed, and I think one of your lordships raised 3.1.7 is follows, obviously 3.2, and 3.2 makes it clear that the whole of this section is subject to there being other rules which say otherwise. So
it's a general rule which is subject to more specific rules.
in my submission, yes.
And that's the point, exactly the point that Lord Justice, I haven't got the judgment here, but if you go to the notes in the White Book, you will see that Tibbles is dealt with, I think, at page 117. Jurisprudence had laid down firm guidance as to the primary circumstances in which the discretion may, as a matter of principle, be appropriately exercised, namely normally only A, where there's been a material change of circumstances since the order was made, which is the usual one, or B, where the facts on which the original decision was made were innocently or otherwise misstated.
My Lord, yes, and I see earlier in that paragraph.
And it doesn't give some general power of review under inherent jurisdiction or otherwise to the Court of Appeal in respect of decisions of single Lord Justices. That's all dealt with by 5230.
My Lord, no, indeed, and indeed considerations of finality are specifically raised at the third line of that very paragraph. In addition to which we have the point that I think your lordships have made a number of times, which is that there is a a hall of mirrors, endless iteration of this, if we do accept that this matter is correctly argued as a matter of principle, there is in fact no end to the situations in which one could argue that the decision below is void, such that simply asserting that something is void, I get another bite of the cherry. In my submission, that can't be right. I do make the, and forgive me if it's a slightly jury point, however, that the extent to which that argument has been relied upon, the force and length at which it's been argued, do undermine my learned friend's case that he actually meets the 5230 test as properly applied and as correctly viewed. It is, in my submission, difficult for him to maintain the point that he makes, whilst also alleging that he actually meets that test if it is looked at correctly. If I may, then I'll simply turn to the 5230 test, which, as I think your Lordship suggested, is the logical route for the court to consider first whether 5230 is met, and then, if it is, to consider the merits of the appeal. Most conveniently, I suggest that the principles to be applied can be taken from the recent case of Khan and Secretary of State for the Home Office. That's at 34 in the jurisdiction authorities. Yeah. And in particular, starting at paragraph 17, which sets out CPR 5230. Pause to note, and I think it's common ground, that 5230 is a cumulative test, so that each of the three requirements of 5230 must be met in order for the appeal to be reopened. And then at paragraph 18, there's a section from Goring on Thames which we've just looked at, and I take your Lordships in particular to the section beginning "It's exceptional," referring to the exceptional jurisdiction of 5230, where it says it's exceptional in the sense it will be engaged only where some obvious and egregious error has occurred in the underlying proceedings, and that error has vitiated or corrupted the very process itself. Now, there have been various authorities dealing with what would be sufficient to meet this. If I could take you quickly to authority 25 in the bundle, which is Lowell and Circle 33 Housing Trust, paragraph 65 of that judgment.
Sorry, which?
Forgive me, permission 25, so tab 25, please, and paragraph 65.
This is Circle 33.
Yes, my lord, and so that's page 190 in the internal referencing. Forgive me, I think my learned friend and I are both slightly wrong-footed by the fact we had all PDF references for our authorities.
So which paragraph?
So it's under the heading discussion, paragraph 65. It's at page 190 of the internal references. And it's around about the middle of that paragraph, there's a sentence beginning accordingly. Accordingly, and this is Sir Terence Etherton, thirdly, the jurisdiction under, as it then was, CPR 5217, can only be invoked where it's demonstrated that the integrity of the earlier litigation process has been critically undermined. The paradigm case is where the litigation process has been corrupted, such as by fraud or bias, where the judge read the wrong papers. These are not the only instances. In my submission, the point to be taken from these is this: the sort of circumstances in which a decision could be vitiated are circumstances in which competing public policy aims to the public policy aim of finality come into play. There's a public policy in the neutrality of judges, public policy in their competence to read the correct papers, and those are the sorts of public policy considerations which could properly vitiate a process and which are properly to be balanced against the need for finality. They're to be contrasted with the sort of things that my learned friend was suggesting are sufficient to vitiate a litigant's belief that the judge has missed his point or got something wrong. That is not the sort of public policy reason that would be sufficient to vitiate an earlier decision. So the principles to be applied are, in my submission at least, clear, and I'll now just take your Lordships through each limb of the test, which, as I've noted, is a cumulative test. Mm-hmm. The first of it, the necessity to avoid real injustice. Your Lordships have read the judgment. You'll have seen that the overall findings of the judge were that these individuals made payments to themselves that were not proper, not reasonable, or in good faith. And that's from paragraph 90 of the judgment, page 43 in the bundle. that by using the main asset of the company, they failed to promote the success of the company and foreseeably jeopardised its success, failed to exercise due diligence, put themselves in a position of conflict, and were in breach of fiduciary duty, and that's in paragraph 93. There was a strong indication of dishonesty, albeit the test was not met. And then at paragraph 107, in relation to limitation, the learned judge found that the appellant and his second respondent had derived economic benefit from the transfer of the property, which amounted to a conversion of the property to their own use. Now, none of these findings are challenged in the context of a test which requires your lordships to find that there would be that it is necessary to avoid real injustice for this appeal to be reopened. Rather than challenging any of those findings, the appellant says the court wasn't entitled even to consider these issues. The appellant could act as he chose, provided he did so in concert with the second respondent, and his conduct can't be scrutinised by the court or called into question on any basis. We looked at the test in Lowell that says the injustice to be perpetrated must be so grave as to overbear the pressing claim of finality in litigation. And in my submission, any argument here that a grave injustice could be resulting from the appellant being obliged to return the property to which he had no entitlement and which he awarded himself in breach of fiduciary duty is untenable. In my submission, the opposite is the case, and allowing the appellant to proceed in these circumstances would be assisting him to retain a benefit that he has unjustly obtained. Even in my submission, if one takes a more narrow meaning of injustice, i.e. that something has gone wrong with the process of justice, then with the exception of the ambitious arguments relating to 5230 that my learned friend has just raised, there's simply no basis for an argument here that there has been any injustice. Nothing has happened which could properly be said to have vitiated or corrupted the process. My learned friend appeared below. Each party put their case and was heard and received a fully reasoned judgment. The learned judge at first instance entertained an application for permission to appeal, which was rejected, and then Lord Justice Popplewell entertained an application for permission to appeal, which was rejected. The process has been impeccable in my submission. Turning to the second test, that the circumstances are exceptional. Well, again, in my submission, there is simply nothing here which is in any way exceptional. And in fairness to my learned friend, I'm not sure he even asserts that there is. I'm not sure he actually has addressed the second and third limb of the 5230 test at all.
His whole argument the court somehow has a residual power to review. It is really predicated on it not being exceptional, but that being something that happens in every case in which the initial Lord Justice or Lady Justice refusing permission to appeal has got the law wrong.
My Lord, yes, perhaps.
So it's not an exceptionality test on Mr. Adams' submissions.
My Lord, yes, perhaps the only exception in his submission being some frivolousness hurdle, which once you meet it, but the suggestion that a case is not frivolous, but the litigant nonetheless thinks the judge at first instance got it wrong, it is in my submission far from exceptional. Finally, no alternative remedy. Perhaps unusually in this case, my learned friend also actually fails to meet this requirement. You'll see at the supplemental bundle at page 49, you'll see an early order of the court which relates to my learned friend reserving his right to serve contribution notices. No, forgive me, it's page 48. And then at 49, for the avoidance of doubt, the first defendant, which was the appellant, and second defendant have permission, if so advised, to make applications for permission to file and serve such notices of additional claims for contribution as they think fit after judgment has been handed down in relation to the claim against the first and second defendants. You will, my Lord, I'm sure, have seen that the paragraph 102 of the judgment, which is at page 45 in the bundle, the judge at first instance considered that the appellant and the second respondent had been beguiled into their behaviour by professional advisors. They were originally defendants to these proceedings, and contribution proceedings in relation to them. The right to bring such proceedings have been expressly reserved. Even taking my learned friend's case at its highest, if I could take you to page 132 in the supplementary bundle, and paragraph 19, just to be clear, this is a section of Mr. Adams' further submissions in relation to permission to appeal. Paragraph 19, he says, the claimant does not have any alternative effective remedy. Any claim against the professional advisors who advised him as can in relation to the transactions is, I'm quoting, so my lord says, paragraph 19 at 132 of the supplementary bundle. It's really the two words at 3 lines down. The claim is not entirely straightforward. That is the height of it. And then just over the page, we have the witness statement of his instructing solicitor. And at page 134, paragraph 5 of that witness statement, again dealing with this question of alternative effective remedy, 5 lines down at the end of that line. So in the event that this appeal is not successful, he will certainly consider whether that he has any claims against the third and fourth defendants. In my submission, that falls well short of satisfying the third limb of 5230, which requires that there be no alternative remedy. And in my submission, that's the burden in relation to establishing that falls on the appellant. In my submission, therefore, he fails to meet every part of the 5230 test, which is the relevant test, and I therefore invite the court to refuse the application for permission to reopen the appeal. My lord, would it be of assistance for me to move on to the question of permission to appeal if it's...
Well, yes, I think briefly.
I'm grateful. I raise essentially 3 arguments in response to the points made by Mr. Adams. First, in my submission, the issue that is raised in these grounds of appeal doesn't actually address the claim that was brought and upheld against the appellant, so that even if the legal argument about section 39 were correct, in my submission it's not actually a good defence to the claim. Secondly, in my submission it's not correct, and section 39 does not bear the construction that the appellant has placed on it. And thirdly, it's the built-to point. I submit that the position advanced by Mr. Adams is contrary to binding Supreme Court authority in the form of builter. So that first point, that in my submission the issues raised don't address the claim that was brought. The duties that it was alleged the appellant was under, and which the learned judge found that he was under, are set out in section E1 of the particulars of claim. There's no need to take this court to them. They are the familiar duties under section 171 to 177 of the Companies Act. They're all potentially relevant, but 3 obviously are of particular importance here. And one of those is a duty to act in accordance with Craft's constitution. That's section 171. And then if I may just briefly take you to section 172, which is in the permission bundle. Now at this point, unfortunately there's no page numbering for the sections, I don't think, of... This is page 17 of section, which doesn't have full numbering. It's in the first tab, and it is towards the end of that first tab.
Page
Yeah.
72.
So it's section 172 of the Companies Act. It's page 17 of some internal numbering, but unfortunately these are not individually tabbed. So all I can say is that it's approximately 1 centimetre through.
So page 17 at the top of the page.
That's right, but unfortunately that tab has multiple. So it's section 172 of the Companies Act. Yes, so it's 901.
Page 170, yeah.
So it's 901 is the paragraph number, if that assists.
Yeah, 901. Duties to promote
Yes, so that's
success.
so 901. A director of the company must act in the way he considers in good faith most likely to promote the success of the company for the benefit of the members of a whole, and in so doing must have regard amongst other matters too. And there's then a list of 6 matters, and then it's 172 2. Where or to the extent that the purposes of the company consist of or include purposes other than the benefit of its members, subsection 1 has effect as if the reference to promoting the success of the company for the benefit of the members were to achieving those purposes. So whereas here we have a company whose purpose is a quasi-charitable and not-for-profit company, 172.2 places a specific obligation on the director of a company to promote those purposes, and to promote the success of those purposes. There was never any dispute that the decisions that were subject to this claim were taken by the appellant as a director, and at paragraph 56 of the judgment, the learned judge finds that they were taken as directors, albeit he accepted that there was sufficient to justify a finding that they were also taken by the members. In my submission, the duties upon a director under section 171 to 177 cannot be wished away, whether by section 39 or by any other mechanism. It's no answer either to say that section 171 is about directors and not about members, because section 33 of the Companies Act, and that is that internal paragraph number 1609 in tab 1601, sorry.
Yeah.
Provides that the provisions of a company's constitution bind the company and its members to the same extent as if they were covenants on the part of the company and of each member to observe those provisions. So we have a situation in which companies act by human agents. There are different human agents by which a company could act. Relevant to our case, there are directors, and they're under the 171 to 177 obligations, and there are members, and they are under the section 33 obligations. That, in my submission, is the case that the appellant and the second respondent had to meet. That, in my submission, is a case which is not met by saying that the company had capacity to do whatever it wished to do. Whether or not the company had such capacity, they were directors and they had duties as directors which they breached. No appeal has been brought against those findings, and in my submission, they should stand and must stand. If I'm wrong about that, I also say that section 39 does not bear the construction that the appellant puts on it. Section 39 is about the capacity of a company, and we know from the Pepper and Hart note about section 39, 39, which is in the Permissions Authority bundle at tab 26.
Tab?
26, my lord. We know what Parliament intended. Says that the Pepper and Hart note, clause 39 is about protecting third parties from the internal restrictions on a company's capacity that may be contained in a company's constitution. It provides that the validity of a company's action not be questioned on the grounds of lack of capacity, etc., etc. It is about the protection of third parties, those who deal with a company, and it prevents a third party's claim from being defeated on the basis that the company says our internal constitution prevented us from doing this and therefore I defeat your entitlement. That is its purpose. That is clear from the surrounding sections of the Act. It is clear from sections 171 to 177, directors' duties. It is clear from section 33, which we just looked at in terms of the power of the members. And it is clear that for internal company purposes, the Constitution matters and is binding. It's clear in addition because, of course, of section 62. And section 62 was raised by the claimant at first instance because if it is asserted that a company's constitution is irrelevant, it doesn't matter what the constitution says, everybody can just act as they choose provided it's not actively unlawful, then section 62 is both otiose and illogical. If it doesn't matter what the constitution says and I can act otherwise in any event, then why has Parliament ensured that I can only have a company which does not use the word limited in its name, provided that I meet a not-for-profit condition? What possible purpose could be served by such a provision? And worse, what possible purpose could be served by a provision by which attempted amendment of those articles is made a criminal offence when I don't need to amend the articles, I can just act as I choose, without reference to them? it would make no sense of any sort. That is the basis then of my submission that even if it were right that section 39, that somehow directors' duties and members' duties could be wished away, they certainly can't be by section 39. So that in my submission, in the case of a company such as Craft, certainly, the articles do bind the members. They're binding unless and until they're amended, but in any event, in the case of this company, and the constitutional provision that we're talking about, clause 5, the non-distribution clause, that was not something they weren't free to amend, certainly not without a public statement to that effect by means of changing the name of the company. And just a final pepper and heart note on that, which is the pepper and heart note to section 63, and that's at the very back of the commission authorities, the final authority, the final tab. It's a section of the House of Commons. It's the second column of the very last page in the bundle. There's Vera Baird is in bold, and it's the second sentence of this, which is a section about clause 63, which became section 63 of the Companies Act. The policy, she says, is that the companies to which the clause applies should use all the money they have available in promoting their objects. That is the policy. It is not that they should be wholly free to ignore them, as suggested by my learned friend. If it's a criminal offence under section 63 to seek to amend the articles, it must follow in my submission that simply acting in contravention of them without amendment is impermissible. My third and final point is the built-to point. So in my submission, what Mr. Adams says is contrary to binding Supreme Court authority. We've looked at paragraph 7. This is, of course, a decision which postdates the 2006 Act. A number of paragraphs are quoted by the learned judge at first instance, and all of them are relevant. But as your lordship pointed out, really the point is encapsulated at paragraph 7 in the judgment of Lord Neuberger that you went to earlier. If it were correct that a company can do whatever it wishes, provided that the directors are the only members and they act in concert, then paragraph 7 must simply be wrong. It's binding on this court, on all of us, and therefore this is not an argument that could succeed. I'd ask you also to look at paragraph 42 of that judgment, which is a section of the judgment of Lord Mance.
Sorry, which tab is built up?
Sorry, that's at 26.
22.
22, sorry.
Paragraph 42.
Yes, it is tab 22, sorry. So paragraph 42, yes, so we've looked at paragraph 7. If I could just take you in addition to paragraph 42, which is a section of the judgment of Lord Mance, where he says this: where the relevant rule consists in the duties owed by an officer to the company which he or she serves, then whether they are statutory or common law, the acts, knowledge and states of mind of the company must necessarily be separated from those of its officer. The purpose of the rule itself means that the company cannot be identified with its officers. It is self-evidently impossible that the officer should be able to argue that the company either committed or knew about the breach of duty simply because the officer committed or knew about it. This is so even though the officer is the directing mind and will of the company. The same clearly also applies even if the officer is also the sole shareholder of the company in or facing insolvency. Any other conclusion would ignore the separate legal identity of the company, empty the concept of duty of content, and enable the company's affairs to be conducted in fraud of creditors. Those points in my submission put my learned friend's argument to bed. I raised very briefly the point that this argument that's now being advanced has certainly, in relation to section 62, was not raised at first instance. You have the opening and closing submissions. if this court were to be considering whether or not to grant permission to appeal, it would of course need to be satisfied that these points have been fair in first instance. And I'd invite you to consider that. And those, my lord, subject to any questions from the court and my submissions, savers would potentially relate to R2, but I think perhaps. Great.
Thank you very much. Yes, Mr. Hibbs.
Good afternoon, Your Lordships. I appear on behalf of the second respondent on a pro bono basis. I'm aware of the time. I've set out the second respondent's position in my skeleton argument. The second respondent takes no position on this appeal, save that if it's successful. If this application is successful, then the stay applying to the first instance proceedings should apply to both the appellant and the second respondent. I've set that out to my skeleton argument. My only other point is that it would require having two separate relief hearings, which would not be proportionate. Those are my submissions, and then I can be, unless I can be of any assistance.
Thank you very much. Yes.
My lords, in my submission, the finality with which this court is concerned at this stage is my client's entitlement to a final decision of this court in open court and properly argued if there is a proper issue which warrants an appeal. As far as the jurisdiction is concerned, my lord, I apologise if I should have referred your lordships to Tipples. I've had a very quick look at it. It's in very, very different circumstances to this. And if it is just a statement of practice, then for the same reason as stated in Gourlay, your lordships are not bound by it in any event.
Well, neither would a first instance judge be bound by it, is that right? If it's a statement of practice, then it's not binding on any court.
Well, my lord, I
time
think
and time again, Tibbles has been followed by judges of the first instance, by judges of this court, many, many, many times.
Well,
For nearly 10 years.
my lord, the rubric in Gourlay, which has always been the position, is it's principally for this court to supervise and develop the practice, and as is stated in Gourlay, if the statements of practice need to be brought up to date to address those issues. But my lord, if I'm wrong about 3.17, then I do rely on the court's inherent jurisdiction. And my lord, in particular in relation to that, I rely on what was said by Lord Justice Robert Walker in Rinaker, tab 14. This was a case where it was affirmed on the basis of Lane and Esdale. There was no appeal from a decision of a lower court against its refusal of permission, and 54, section 54 of the 99 Act precluded it. But the passage I particularly rely on is the passage of paragraph 10. This is being a post-CPR case, where Lord Justice Robert Walker refers back to beeline and macro as to that a court always has an inherent jurisdiction, somewhat similar to the process of judicial review, but distinct from it, to review decisions of officials of the court, such as taxing masters, who are acting as delegates of judges. And my lord, when in my submission the single Lord Justice sits in his room without argument, looking at the papers, he is not determining any issue as between the parties.
It's a decision by a judge of the Court of Appeal, not by a delegate of the Court of Appeal. Read on to paragraph 12.
Well, my lord, that is why there's no
Argument that
appeal.
The Court of Appeal nevertheless retains an inherent non-statutory jurisdiction to hear appeals, whether that is necessary in order to correct errors in the court below, is unsustainable.
And my lord, that is the rule in Lane and Esdale, which is this is not an appeal. It is a review in the nature of a judicial review. The court must have such inherent jurisdiction to fulfil its role as a court of justice. Because otherwise it is leaving it to the single Lord Justice. If the single Lord Justice...
Why is that any different from the decision of the High Court judge in that case to refuse permission to appeal from the cost judge? It's a refusal of permission to appeal, and as Lord Justice Robert Walker says, it cannot be regarded as a decision taken as delegate of the Court of Appeal, and the relevant judicial functions are quite different.
Well, my Lord, that is not a delegate of the Court. The High Court judge is not a delegate of the Court of Appeal, because an appeal to the Court of Appeal was only by leave, and that is the formulation that was adopted to explain, and that explains Lane and Esdale in Rickards and Rickards. It's cited in Kemper at 16D. All that Lane and Esdale decided, and all that it decided, was that where it is provided that an appeal shall lie by leave of a particular court or courts, neither the grant nor refusal of leave is an appealable decision. So, and they go on to emphasise also on later on in the paragraph that if a principle in Lane and Esdale, if applicable, excludes an appeal against the grant of leave just as much as against its refusal, which is why, my Lord, if there was no jurisdiction for review, CPR 5218 would be ultra vires, whereas in fact 5218 is a perfectly conventional application of the court's inherent jurisdiction over its procedure to ensure that justice is done in the case. And if the court can entertain application under 5218 from the respondent, it equally can entertain application from the appellant. My Lord, if my submissions are right, it would be invidious and unnecessary to criticise the decisions of the single Lord Justice, who admittedly had to deal with the matter at very short notice, given its urgency. And, but I do rely on paragraphs 5 to 7 of my further submissions in support of the review, that in essence the judge misinterpreted the judge at first instance judgment. And that, most obviously, in not dealing with my point, that the judge, it was improper for the judge to draw a distinction between the capacity and powers of the company. He inappropriately expressed his own views as to whether the judgment was right. It's not the job of the single Lord Justice to consider whether it's right. That is the job of the full court. The job of the single Lord Justice is merely to consider whether there is an arguable point. In other words, one that there might be a point of disagreement in the court.
Well, you will be writing many reasons given by Lord and Lady Justices for refusing permission to appeal, Mr. Adams, because one of them, many times, people say, I consider that the learned judge was right for the reasons he gave, and that's why they refused permission to appeal.
Well, my Lord, if all the judge at first instance has done is applied settled law, then that's a perfectly proper reason to give. If, however, the case raises an important point of law, as the judge identified at the very outset of his judgment, there is a point of law in this case. My learned friend, with her references to Pepper and Hart, should not fill this court with confidence that it has been settled to the extent that it is not arguable either way. And also, he either failed to understand or grapple with the essence of the argument, which is about capacity and the capacity of the members to act unanimously. My Lord, if I need to look at, if I go through 5230, and 5230 does apply, then I say it is necessary to avoid a real injustice. The injustice is the deprivation of my client's right of access to this court. And the opportunity to argue that the learned judge at first instance got it wrong. It's, and as I mentioned in opening, the right of appeal was recognised at common law long before any statutory rights of appeal. The circumstances are exceptional and make it appropriate to reopen the appeal. I say exceptional in those circumstances in procedural context means the same as Dillux. The court is concerned to do justice at this stage, not to set aside something in order to avoid an injustice, and therefore it is not a high bar. It just is taking it outside the general rule on the same logic. But even if justice demands, in my circumstances, in my submission, there is a plainly arguable point of law that makes it appropriate to reopen the appeal. My Lord, there's one other matter that I didn't mention, but of course, because the decision is taken in private, it's impossible to know what matters the single Lord Justice did take into account. But for what it's worth, representations were put before him by the respondents, which were factually inaccurate. In the suggested paragraph 2 of the respondents' submissions at tab 13, that points on section 62 had not been raised in argument. And for what it's worth, the transcripts of the relevant sections of argument have been put in the bundle. The bottom line is there is an important and arguable point which has not been determined and on which I'm entitled to a determination. There is no alternative effective remedy. It would be wholly wrong to leave my client to uncertain claims against professionals, who themselves, no doubt, if they did have an indemnity, would want to be subrogated to this claim anyway. The fact that the professionals may be insurers for my client in these circumstances is not something this court should take into account, and certainly cannot reach a conclusion on that I have an effective alternative remedy so as to deny me my right of appeal to the Court of Appeal. And my learned friends made a number of points on the Companies Act. Section 63 does not make it a criminal offence to seek to amend the articles, as my learned friend says. It is a criminal offence to amend the articles, presupposing that the membership can, and not and to continue to trade with limited in the name. Now, it may well be that certain circumstances that can be entirely technical, and nobody knows about it for a long time, and in the public interest, no prosecution could be justified. But if my learned friend is right, and this demonstrates why the point is arguable, everything that had been done by that company in the interim would be ultra vires, or potentially. Or my Lord, unless there are any further points I can assist your lordships on.
No, thank you very much, Miss Adams.
You know, for time, may I just respond on the assertion of factual inaccuracy in the respondent's submissions?
Yes.
It's simply that if you read what we said, it was that the point on section 62 was not put below as it is now put. It was not put in writing, either in closing or in open submissions. The full extent of the oral submission made by Mr. Adams is at page 186 in in a supplementary bundle if your lordship's considering. I do also, I object to my learned friend's application in relation to the second respondent, but I think, my lord, unless it would be helpful for me to explain why.
I don't think so. Right, well, we will reserve judgment in this matter, and you will get a draft judgment in due course for any typographical errors, not for re-argument. And if you could please agree a form of order before any hand down. If for whatever reason it's not possible to agree a form of order, then the court will deal with the matter by way of written submissions. But, thank you very much for your interesting submissions.